Hey there, and welcome to the behind the scenes of the Rustic Songbird podcast. I'm Lydia Walker from rusticsongbird.com, and I'm taking you behind the scenes of an interview on the podcast. I hope you enjoy this video, but before we get started, I want to invite you to subscribe to this channel. If you enjoy topics like this, we have new podcast episodes coming out every single week, and the behind the scenes will be here on this YouTube channel. So make sure to subscribe so you don't miss anything. Also, if you enjoy this show, consider becoming a patron and supporting Rustic Songbird on Patreon. You can check out all the details at patreon.com/rusticsongbird. All right, let's get into today's show. My guest on the show today is Shawn Thompson, and we're going to talk all about how to copyright your music online and make sure that your songs are protected. This is a topic that comes up over and over when I talk to musicians that are wanting to put their songs out there. There's this fear of getting your songs out there, and if it's not copywritten correctly, they might get stolen or somebody use your song, or you not get credit for art and things that you've created. So that's why we're talking about this today, to kind of clear the air and figure out what is it that is required to make sure your songs are safe, protected, and copywritten in the correct way. And so I have Shawn on the show to talk about that today, and she can go into some of the basics of what it actually means to copyright your song, and we can go over some of the common questions. So Shawn, welcome to the show.
Thank you. Thank you so much for having me.
I appreciate you taking the time. We haven't had an official copyright expert on the show, and so this is something that you talk about, and I've loved the videos that you put out on Instagram, just sharing really basic information about what copyright is, how it works. I think that's so helpful for musicians who don't just delve into the fine print and to all of the legalese language that can be so confusing if you don't read it every day. And so what I wanted to do today is break it down in a way that's easy to understand, coming from the perspective of a musician who's wanting to put their music out there and just make sure it's protected. So that's what we're talking about today. But give us a quick, just a few minutes about why you're so passionate about working with copyright and kind of what got you into doing that as a career.
Yeah. So I always kind of joke that I wasn't born with any sort of musical talent as much as I wanted to be and as much as I've tried. And so I figured out kind of early that I wanted to still be able to contribute to music in some way. And that way was on the business side. So I had an internship right after high school where I was able to work directly with musicians. And that was kind of my first taste of, figuring out what their concerns were, and especially going into signing recording agreements and publishing agreements and things like that. I think a lot of musicians and songwriters felt like they were being talked down to, or it was just very intimidating to figure out what they were signing, and nobody was really taking the time to explain it. So that was kind of my passion and motivation. I went to law school and I studied all the entertainment related classes and things like that I could. And then while I was still in law school, I started an internship at a law firm in San Francisco that directly represents artists. And I was there for about 8 years before I moved to Nashville, and I started at WME, which is an agency. So now I still represent artists, but mainly on like the live performance side.
Mm-hmm.
But I have this Nashville Music Attorney Instagram, and the idea behind making these videos was, again, to go back to my roots of really wanting to help artists to understand the business side of what they're doing. And I think there's a lot, they can be kind of intimidated in thinking that, well, I should say, it's not necessarily just intimidation. It's that these agreements and copyright law, these things are written to not be easily understood.
Right.
And it's even hard for me to understand. And I studied it for,
Right.
3 years in law school. So I wanted to create something that was easily digestible for people to understand, because this is their work. This is your passion, and it's something you want to protect and you want to exploit. So if I can just break it down a little bit more, to help you understand it, then that makes me happy. And that's what I got into this to do.
Yeah, and I think it's really helpful to know that you don't have to study this for years to do it correctly and make sure that your songs are correctly registered and copywritten. And it just seems like kind of a vague thing when you're putting out music. Somebody that's a musician and a songwriter might write the song and then record it and then get to release it, and they want to print CDs and they want to put it out on iTunes and Spotify, and then they're like, oh, like copyright is an afterthought, like, oh, should I do that? So we can kind of talk about when, I guess this could be a good first question. When would you recommend someone registering a copyright for their song? Because normally the advice that I give people is register the songs that you're planning to release and make sure that those are done. But do you have any tips for when to know which songs to register, and how far in advance should they do that before releasing a song?
Yeah, absolutely. So to start with, something that I feel like not everybody knows is that you actually do have copyright protection just as soon as you write a song or record a song. It's this phrase, fixed in a tangible medium. So the second that you record it, usually that's enough.
Mhm.
And that basically means that if you did have to go after somebody for copyright infringement, you could. But the benefit to registering it is that you would get a higher monetary amount if you did have to sue somebody, and it's just good to have. I mean, it's a better protection. So as far as when to do it, I mean, if you can afford to do it as soon as you create a song, then by all means do that. But I agree with you that it's, at a minimum, do it before you, like, right before you release a song. um, or as soon as you do. Another kind of hack is that you can file a a group of copyrights on the same application and only have to pay one fee. So if you have like a group of songs, and even if it's not technically an EP or an album, but you can kind of give it like a title, that's a way that you could just pay. I think it's $55 now, I can't remember, but that's a way that you could pay that amount for like 10 songs as opposed to that amount for each song.
Mhm. Yes, and I think the group of, I think it's up to 10 unpublished works is how you can send that in together. So if it's before the songs are published, then you could take advantage of that and have the one submission fee. I think the money does hold people back, especially if they've written a lot of songs, or if they're writing a song a day or a song a week. It can really add up. And if they don't plan on releasing all of them, then maybe they can start with the songs that they are going to release, make sure those are registered. But I'm glad that you brought up that as soon as you create something, you own it. So you
Yeah.
already do own the copyright. Registering it is just proof. That's something that you can say, at this date and this time, I had this recording and these lyrics. And it's just like an extra layer of protection, but you already own it. This is just
Hmm.
you registering it with the Copyright Office, and specifically with the US Copyright Office. I like to send people to the website, copyright.gov, for the forms. But then if you have never seen the website or have never seen the forms, you can get there and think, what do I do first? What do I do next?
Yeah.
Going through line by line, it's not always very clear how to fill it out correctly. So what advice would you give for someone who is, going to the website, filling out the forms for the first time?
Well, I agree. The website is not as intuitive as it should be. But the Copyright Office does have some really great, like, 1 or 2 page, like, educational materials for pretty much every kind of copyright issue you can think of. So usually if you can just think of the question and Google it, there's probably a PDF out there. But there are a few things a few pieces of advice I could give. One, the the copyright application for a musical composition is labeled as PA, which can be confusing because you're like, what does PA have to do with it? And it stands for performing arts. And once you're under that subsection, it gives you an opportunity to, I think, go down and say, musical composition. If you're registering a sound recording, it's SR. So make sure that you're differentiating those two. And there's also a section in the application that asks you about author and claimant. I think that kind of trips people up sometimes. If you are an individual like singer songwriter, you're not signed to a recording label or a publisher, then you are going to be the author and claimant always. The only way that that would change is if you were signed and you had transferred, ownership of your copyright, in which case the claimant would be whoever you had transferred your copyright to, but you will always be the author no matter what. But like I said, if that isn't the situation, then you will be both author and claimant. So those are two things that I think get people confused on it. I'm sure that there are more, but those are two of the biggest ones.
Yeah, we've talked about publishing on the show too, and that's another thing. You own your publishing unless you sign it to a publishing deal or publishing company, or if you get a record deal, they might have some wording about who owns which part of the publishing. So if you don't have that, then you automatically own your publishing, and you are the writer, you are the author, and so that's good to know and just clear that up. I have heard people say, like, when they go through the forms, they're not sure whether to do a form PA or a form SR or both. So in what situation would they use the form PA, and what situation would they use the SR sound recording form?
So the difference is in who owns the copyright of each. So if you're a singer songwriter, then you're going to own the copyright in both. But say in the pop world, it's kind of more common for somebody to record a song that they didn't write. So the SR application would belong to the recording artist or the record label, and the PA application would belong to the songwriter and or the publisher. So you do have to file two of these applications for every song. There is a rare situation where you can file one, and I apologize that I can't remember right now off the top of my head whether it's PA or SR. But again, this is something that you can look up. I know that there's a copyright handout for it. But in a rare situation where you are the only person who wrote and recorded it, so a solo singer songwriter, you can file one application that will cover both copyrights.
Yes, I think it is the SR. I think I did see that in the information handout.
That would make sense. Yeah, that would make sense because a sound recording embodies a musical composition by nature, whereas the reverse isn't true. But that's a really good hack to save money too. But like I said, that will only work if it's the same ownership. It can't be, different at all.
So if someone is the songwriter and they also own the recording, they've paid for it to be recorded and they own it, then you can fill out the form SR, say that you're the author, say that you're the owner of the copyright. And it's a simpler process if there's, just one owner of all the things. And so I think another question that comes up is if someone's co-written a song and they are splitting the author, the writer and publisher side of things, you would just put all of the writer's information on that form to make sure everyone gets credit for that. So it's important to have all the writers' legal names and their publishing information. I think it's helpful to have that when someone writes the song. So like in my notebook, if I write what day we're co-writing, and then I'll go ahead and make sure I get their legal name and any publishing information, just to make sure that everything's correct when you submit it, because it seems like it would be a headache to have to go back and make changes. Is that correct?
Yeah, absolutely. I mean, that's what I would always encourage. I know that it's not always fun to have that sort of like business conversation when you're in the middle of doing something creative, but I would definitely also recommend as early as possible to talk about songwriting splits too, like preferably before you leave the session or whatever, if you have finished a song. And I know that that's not always the case because again, it can be awkward and it's like, well, I was just creative with this person and I don't want to bring up the hard discussion of like, oh, how much was your contribution worth? But it's really like worth having that conversation as early as possible. I always say you're friends until you aren't. And so, it's best to do it when you're like in good spirits and also when you just wrote the song and it's all clear in your head about how much everybody contributed. But that's a great idea. Get information. I would say also establish who's going to do the registration so that you don't have like multiple, partially just because you don't want multiple people having to pay for it. And then also I think sometimes that can kind of gum up the works at the Copyright Office and they might deny someone's application if there's like duplicates.
Yeah, that's a good perspective on that too, to make sure you know who is registering it so that it does get done too, and don't expect someone else to do it, or just decide either in the writing
Mm.
room or later on and say, okay, I'm going to be registering these songs that we wrote or for this project. I think a lot of times it goes to the artist. So like if you're co-writing with someone and then you're going to release it, then it kind of goes like the ball's in your court to make sure that it's registered correctly. But you can confirm that and make sure with all the writers involved that everybody knows what's being done with the song and how you're going to use it. And then if you have any questions later on, having it in writing is really helpful. So can we talk about that a little bit of as far as like a song split? I know rule of thumb in Nashville is like, even splits, so that there's two writers, it's 50-50. If it's three writers, you split it three ways. I think even just clearing that up at the beginning and letting people know that it can get a little tricky, I guess, when you are working with like more famous writers or artists and they want a piece of a song that's maybe mostly done. There's kind of like ways to get more complicated, but as far as splitting it evenly, that's worked well for me so far, and a lot of my friends that are songwriters do it that way.
Yeah, that's a good point that it can be a little bit different in Nashville. That's what I discovered when I moved here. The publishing world in general here is different than the rest of the country. Um, but yeah, I mean, I think just having the conversation as early as possible, like you said, is very important so that you can manage expectations. Because if a big name artist comes in and they're thinking, I'm going to have 80% of this song no matter what, it's good to establish that so that so that the co-writers can decide if they're comfortable with that or not. Um, but a songwriting split sheet does not have to be complicated at all. It can literally just be the people's names and the splits and then signature lines. And it can be more complicated from there into going into maybe, whether permissions are needed for example, syncs. Some song technically you do need that permission, but some people will waive it. And so what I'm saying is, for example, if the song were to be used in like a commercial or something, some people have a lot more of um a problem with like advertisements. So problem's probably the wrong word, but they just want to be a little bit more in control about how the song is used.
Sure. Yeah.
So sometimes a songwriting split will cover that. Sometimes it'll also cover um that you can't be paid less than a certain amount of the minimum statutory royalties. So there's a few other things you can put in there, but I'd say at the very least, just get the splits and get everybody's like legal information.
Mhm. Yeah, that's a good idea, because if you just write it down when you're in the writing room, or even before, you could say, hey, how would you like to split this? Or if I were to pitch this for something, would you be okay with that? And just making sure you have all the permissions you need from all the writers is good, because that will avoid so many problems in the future if you just have it
Yeah,
out front. And then if they do have a problem with it, ahead of time. And so I think that
right.
will save a lot of trouble later on.
Yeah. And I was also just thinking, if you want to be even more casual about it, you could probably even just do like an email. I don't know how common it is for people to be on like an email thread when they're arranging co-writes or whatever. But even if you just like right after the session is over, sent a quick email that was like, hey, I just wanted to confirm that we decided on a four-way split for this. Let me know if you're cool with that. And then everybody wrote back, yes, yes, yes. That I think would be like held up if it ever like went to a case or whatever.
Right.
So if it's a situation where it just doesn't feel right to have everybody like sign a document, then I would say maybe at least have like some sort of electronic communication where
Yeah.
people acknowledged the splits.
Yeah, so then you have that in writing electronically, and you have a timestamp on it to know this is the date we wrote the song, this is when we talked about it, and so any of that could be used as evidence later on to say yes, we did agree on this certain thing. So I think it's just good to have your bases covered as far as communicating with other musicians and songwriters and make sure everybody knows what's going on. So I do have a question about when would be the time to either like sell your copyright, or when would it be a good idea to um, you know give over some of your copyright to like a record label or to a publishing deal or something, what would you recommend?
Well, I would recommend never selling your copyright, or at least uh, put that off for as long as possible. If it's a money generating copyright, then you should hang on to it. But you can license your copyright, for, I think what's kind of common if you're going to sign with a record label and you've already written the music, or if you're going to sign with a publisher and you've already written the music, then it's a bit more common to do a license as opposed to the record label or publisher owning part of the copyright. And that's actually becoming more and more common nowadays, that it's becoming slightly easier to, you know, produce, release, market, and exploit your music online,
Hmm.
because record labels and publishers aren't quite as, they're not the big dogs in town anymore. People have figured out how to do a lot of this stuff on their own. So that basically means that they don't have as much leverage as they did before to say, hey, we, in exchange for all that we're going to do for you, we need to own part of your copyright or all of your copyright. They just don't have that leverage now. Some do. I mean, I'm not saying, if a record label came to you and was like, hey, we want to pay you $200,000, then sure, you might consider it. But that's, those sort of deals just don't really exist anymore.
Hmm.
And assigning a part of your copyright made a lot more sense when they did, when basically you would make a living off of your deal. But because that's not as common now, I would say hold on to your copyright. You can do a license deal with record labels or publishers, and you can do, there's just more unique ways that you can do deals now, where it's more of like a partnership as opposed to just the record label or publisher owning your work and kind of calling all the shots. Um, so that's like a long-winded way of saying it, but I really just would encourage artists to not sell their copyrights or assign their copyrights. They're kind of to the same terms, but there are situations where it might be worth it to license it for a limited period of time.
Mhm. Oh, that is so good. Yes, that is really good to cover that, because I think it can be confusing as far as like who owns what and when to, give permissions. But I love that there's so many opportunities now for musicians to license their work and get paid for it to be used in commercials or in TV or in lots of different ways and still own it. So in that case, the owner gets the royalty for that. So like for example, if someone's song was to be used in a commercial, they would get paid up front for licensing it, but they also get paid as the songwriter. They get paid if they own the publishing. They get paid if they're the artist. They get paid the royalty if they own the copyright of the recording. And so that can add up. That can be an amazing living for a musician, if it's used in sync. So that's an
Mhm.
awesome opportunity for people. How would you recommend people keep track of like the songs that they've copywritten, the songs that they've written, to make sure that they have the correct paperwork if they need to, show it in some kind of way, if it ever comes into question?
Yeah, that's a good question. I don't think there's one particular way, but when you do copyright your work, they send you a kind of fancy looking certificate. So I would say, hang on to those. Although if you were ever in a bind, I'm sure you could get another one. I would say set up a system, figure out a list of all the things that you need to do when you are about to release a song or you've just released a song. So not just the copyright, but also um, sound exchange, whatever PRO you are, ASCAP, BMI, CSAC, and go down the list of making sure that you have your music registered with all of these discrete companies, because you don't want to miss out on any royalties that are, being collected.
Hmm.
And it it can be a little bit confusing, I know, because it seems like every day there is some new service that you need to, have your music registered with. But I think you'll be pretty well covered if you make sure that it's Copyright Office, Sound Exchange, and whatever PRO that you're registered with.
Hmm.
Those three are really going to cover so much of the royalty income that comes in.
Right. Yeah, I'm glad you brought that up as well because the copyright is one part, but the ones that collect the royalties would be your performing rights organization. And, the top three are ASCAP, BMI, or CSAC. And then Sound Exchange collects different royalties than the PRO does. So Sound Exchange does collect those artist royalties, the performance royalty, and also the copyright owner royalty. And so those are really important to have those in place. And I like that you said set up a system, because you could even make a checklist and say, every time I release a single or I release an album, I'm going to make sure that it's registered with either the Form PA or Form SR, whichever one is best for you. And then make sure that it's registered with your PRO and that you've claimed it on Sound Exchange so that you can get paid for your music. I think that is so exciting and empowering for musicians. And it's just something that we need to talk about, because if you have not looked into it, you might not know how to get paid for your music. And so these are really helpful ways to get started with that. So I want to let people know how they can contact you, Shawn, and get connected with what you're doing. And I know that you do work with artists and help them if they do have more advanced or complicated things that they want to talk through, if they want to talk through contracts and make sure that they are getting a good deal. So what's the best way for people to get connected with you online?
Yeah, the best way right now is through my Instagram, which the handle is at Nashville Music Attorney. And once you're there, I believe there's a button to email me if you want to contact me that way. And I've been doing these music law, like 60 seconds of music law series for a while. I want to say weekly, but I can't always guarantee that. So I do my best. But yeah, I love helping artists, even if it's a quick message to me on there saying I'm confused about XYZ. I try to respond to everybody and give them more clarity.
That is so helpful. I love what you're doing. I really appreciate those videos, and I try to share them out. And when I get questions, I want to be able to send people to you as well. So thank you for your time, just talking through some of these common questions to help clear it up and to help people get started in the right direction. I appreciate your time today being on the show.
Thank you so much. This was great.
Also, if you enjoy this podcast and want to show your support, consider joining our Patreon community to support us on a monthly basis. You can check out all the details at patreon.com/Rustic Songbird. That's patreon.com/Rustic Songbird to become a patron today. Thanks again for watching, and make sure to subscribe. I'll see you in the next video.